I'm Rebecca Wright of Rathbone Group, and on this episode of On Subrogation, we are going to talk about service via electronic mail and social media. Now, these types of electronic service have been used occasionally in cases in New York, New Jersey, and California over the last 10 years or so. But it's only been very recently, in fact, since January 1st of 2019, that any state has specifically allowed this type of service under its civil rules. And that state was Alaska, which modified its civil rule 4E to allow for service via electronic mail, social media, specially created court bulletin board system, as well as other types of electronic mail. Even more recently, on December 31st of 2020, the new Texas civil rules went into effect, allowing for the alternative method of service via electronic mail, social media, and other electronic means. So what does this mean for your subrogation case? Well, if you have tried unsuccessfully to serve your defendant via traditional methods such as certified mail or personal service via a sheriff or a process server, but you've not been able to do so, in both states, you can apply to the court for permission to serve your defendant via one of these electronic means. Now remember, this is an alternative method of service. So the first thing that you are going to have to do is you're going to have to provide an affidavit with your motion that demonstrates that you have made attempts to serve the defendant via traditional means. So that means showing that you sent a sheriff or a process server out to this person's last known residential address or place of employment to try on multiple days of the week at multiple times of the day to serve this person and have been unsuccessful. Or that you have tried serving via certified mail, that you've made reasonable attempts to contact this person in the traditional methods. Once you have established that, the next thing that you need to do is you need to show the court that you have identified a specific electronic method for service, be it a specific email address or a specific social media account or some other means, and that you know that the defendant owns that particular address and has access to it, and that the defendant has accessed that account recently or regularly accesses that account. Specifically, the Supreme Court of Texas noted when it adopted these new rules that in determining whether to permit electronic service of process, a court should consider whether the technology actually belongs to the defendant and whether the defendant regularly uses or recently used the technology. But what if the person that you are serving is an individual and not a business? Well, that may be a little bit more complicated, because not only do you have to prove that it is your defendant who owns this particular Facebook or LinkedIn or email address, but you also have to show that they regularly interact with it. If it's an email address, you likely are going to need to show some sort of history of interaction with the defendant. Has the defendant sent you a message from that email address before? Have you successfully reached them and they've, gotten into the details of the case and indicated that this is in fact them? Then you may have a pretty easy time of it. But just showing the court an email address for fluffybunnies@hotmail.com is probably not going to get you there. With regard to social media accounts, there are some more things that you can do to try to link the defendant to the account. For one thing, if you have done some background checks or private investigation of the defendant, you may already have a list of related individuals, related parties to the defendant. In that situation, you can look at their social media account and see if they are friends or related to those other individuals' social media accounts as well. And if that's the case, or if their social media account shows that they work where you know that they work, or live in the same city and are related to these other people, then you may be able to prove that in fact this is their social media account. You also have to be able to show that they regularly access that account or that they recently accessed that account. So you're going to need to look at their public-facing actions on social media. Have they been tweeting from that account? Have they recently changed their profile picture on that Facebook page or that LinkedIn account? And so on and so forth. All of these are ways that you can show the court that the defendant does have control and is accessing this account. At the end of the day, though, even though these methods are now permitted specifically in the civil rules, the court still has discretion as to whether or not they are going to allow the service in your particular case. So you want to make sure that in your affidavit and in your motion to the court, you are specifically laying out all of the reasons why this service should be permitted and why you know that this is in fact a good way to get a hold of the defendant. Because at the end of the day, the whole purpose of service of process is to satisfy due process, the defendant's constitutional right to know that this action has been filed against him or her, and to give the defendant an opportunity to respond. The other thing to remember specifically about the new Texas rules is that they do not apply retroactively. That means that if you have a lawsuit that you filed prior to December 31st of 2020, you will not be able to avail yourself of the new option for social media under this new section of Civil Rule 106. If your case was filed after December 31st of 2020, you'll be good to go as long as you followed the steps that we outlined above and the steps that are laid out in the rules. If you would like to hear more about this topic of service by social media, I encourage you to check out our podcast on subrogation, which you can find on iTunes, Google Play, or wherever you get your podcasts. If you'd like more subrogation information, please check back here to our YouTube channel for more topics to help you with your subrogation practice. Until next time, I'm Rebecca Wright for Rathbone Group, and that's the long and short of it.